Hi, Lee Phillips here, and I want to talk to you about what I'm going to call business succession planning. What does a little business do when its owner dies? Well, 95% of the time, the business fails. And the number of businesses that survive the death of the founder, the owner, original owner, are just tiny. So if you want the business to survive at all, you're going to have to do some planning. One, who's going to take over when this guy dies, the original owner dies? Could be the sons or the daughters or the wife or maybe Joe or who, a major employee. But that's something that has got to be considered. And there actually needs to be something at least talked about as to how it's going to work. Then you've got to figure out how's it going to work from a legal standpoint. If dad owns all of the stock, all of the membership interests in the LLC, then how do we get that to the sons or the new guy, Joe, or whoever's going to start to manage and take over this thing? Now, mom's going to want it if dad dies, because that's frankly the major value of her estate, probably. And yet, there isn't any value in it now because dad's gone. So, legally, we need to make the transfer of ownership, and we need to make it easy. The only way you can do that, well, that isn't true, but the only way you can do it that should be done pretty effectively is to have the stock in the company. Now, if this is a subchapter S stock, then you're going to have a trust that is subchapter S qualified. And that trust is going to have to own the stock before dad dies. It has to be subchapter S qualified in the trust, and there are 6 or 7 points that have to be there. Basically, the IRS is concerned as to who gets the money. Subchapter S is a pass-through, so they want to know where it's going. And if it goes into a black hole trust, then we got a problem. So the trust has to be written for subchapter S stock. That trust owns the stock. Then when dad dies, we can make the transfer easy because the owner didn't die. It's the standard probate problem. But if dad's trust or if dad's business gets caught up in probate for 5 years or 3 years or the average year and a half, then it's up in the air and we don't know what to do with it. We can't give Joe an interest in it right away, so that he'll take over and start to manage it so mom can continue to get an income out of it. So the stock or the membership interest, and it doesn't matter whether it's stock or membership interest, if it's taxed as subchapter S, then we need the subchapter S trust. If it's taxed as a partnership or a sole proprietorship, then that's not particularly of interest to us, in that it doesn't have to have a specially written trust. Any trust will do, so to speak. And so the ownership, the membership interests, or the stock needs to be held in a trust. Now, it is possible to do this succession planning actually in the articles or the operating agreement or the bylaws. You can write in the bylaws and the operating agreement that when dad dies, his ownership is divided up this way. And that will avoid probate, and it will allow the company to transfer ownership to transfer that. Usually that's not done. It's, I'm going to say, a little cleaner to do it in the trust, but it can be done in the operating agreements or the bylaws, and the succession can be named and the ownership can be transferred in those documents. But we get into some issues with that because dad's dead and we have a thing that needs to be done that dad can't really do, but it's planned. So I'd prefer to see it in the trust format moving forward rather than the actual operating agreement or the actual bylaws. But it could be done that way. So it's critical that you think, who can do this? Maybe we need to have 2 people on the signature card at the bank account and 2 people who can manage the merchant accounts and all of that sort of stuff. Mom could be put on. The fact that mom signs the signature card at the bank with dad, and I'm talking about little family companies here, okay? The fact that mom is on that signature account doesn't give her any liability, particularly, except to the IRS, in the liabilities of the company. The fact that somebody can deal with the merchant account, that doesn't expand the liability of that individual, really, because they're not officer, director, owner of the company. They're just an employee, and about the only one that can really go get just an employee is the IRS. If you sign the checking account, you're liable to the IRS for unpaid taxes. So think about it. What happens when dad has his heart attack tomorrow and he's not here? How does the business move forward? And I understand you're worried about just operating the business today, but you need to think about operating it tomorrow too, when dad's not there or the owner isn't there. And if you're the primary employee of this company, not related, you need to think about that too, and that needs to be a question that needs to be asked. It's a fair question to ask. So succession planning in a business is pretty critical if you want that business to continue on after dad, the owner, the founder dies. And even larger businesses with 1,000 employees, the chance of that business surviving the death of the owner for 5 years isn't good. It will wind down. I call the guy the gyroscope. He's the one that created it. He's the one that thinks it through. And who's going to think it through after that guy's gone? That's something you need to think about even in a bigger business. This is Lee Phillips. Now don't forget to subscribe. And we're happy to notify you when we put out new YouTubes. We try and put out a couple of 3 or 4 a month at least, but subscribe and we'll keep you posted, okay?